Vice-Chancellor, distinguished guests, colleagues and students, as Dean of the Faculty of Arts and Humanities, it gives me great pleasure this evening to welcome you to the third lecture in this distinguished law series at Liverpool Hope University. It's particularly great to see such a large audience again, so that's wonderful. And also to welcome guests from outside the city as well. We have Madras Christian College with us tonight, so you're very welcome. Thank you. I'd like to say a few words in introduction and to Justice Headley, and my apologies to those who heard some of them before, but I am conscious that each of this series of lectures are standalone, and therefore some of you may not have been here for the earlier ones. So I do apologise if I'm repeating myself a little bit. But first, you're very welcome, as I said. And Justice Headley, as you may know, has had a very distinguished legal career. Certainly will be known to many of you in Liverpool and beyond. He served as judge on the Northern Circuit Court for a number of years, until in 2002 he was appointed to the High Court, where he served in the family division before he retired in 2013, although I think retirement may be a bit of a misnomer in this case. He made history by being the first judge to allow journalists into the court on protection in May 2010. And he's certainly not one who shied away sometimes from controversy. As a judge, he's faced some very difficult decisions in his time. In his career, he's made judgment on a number of high-profile cases in the fields of criminal, family, end-of-life, medical, and mental capacity law. In 2004, he ruled in the case of the premature baby Charlotte Wyatt, deciding that her life support machine should be turned off. Obviously a very difficult decision. He has in many such cases faced highly challenging and difficult issues. And I think we're going to see tonight again, as he ventures into the private sphere, the challenges that lie around that distinction. He has indeed also appeared as an expert, I mentioned before on ITV documentary series Exposure, and he's been a visiting professor for the Judicial College, and is currently honorary professor of law at Liverpool Hope University in our law department. He's also a practicing Christian, an Anglican reader in St Peter's Church in Everton, and Chancellor of the Anglican Diocese of Liverpool. In this series of lectures, he's been focusing very much on issues such as the use of televised trials, the infallibility of truth, state intervention in people's private lives, and whether the role of the judge is fit for purpose in today's society. In his first lecture, he focused on the modern judge, power, responsibility, and society's expectations. And then in the second lecture, what is truth, the relationship between truth, proof, and justice. In tonight's lecture, he turns his attention to the state and private life. Should the state intervene to protect? In this lecture, he examines the balance between the state respecting the right to private life, which is enshrined in human rights and British values, versus the need for the state to intervene in private life to protect others. On what basis, then, can the state intervene in private life? A highly controversial topic in its own way, and I think we look forward to hearing Sir Mark's views on this. So with no more ado, I'd like to invite Sir Mark Headley to give his third lecture. Thank you.
Vice-Chancellor, distinguished guests, ladies and gentlemen, thank you very much for coming tonight. Thank you for your continuing support for this series of lectures. The purpose of the series, as I've tried to say, is to talk frankly about judging and to use as the model of doing so the trial judge in the family division and the Court of Protection, particularly in relation to the range of discretionary powers that are committed to those judges. Underpinning this series are two questions. First, what is the true extent of those discretionary powers? And secondly, and perhaps more importantly, are they exercised with the informed consent of our society? We have seen how our system, like any and every other human justice system, is hardwired to fallibility. Yet judges are required to make decisions and to resolve disputed facts. Any failure to do so in itself results in injustice. and we looked last time at the tensions inherent in proof, truth, and justice. We have seen, as we will see in every lecture, the conflicts between perfectly valid principles that nevertheless pull in different directions. So we have seen the tensions between privacy and transparency, between proof and truth. And we have seen too how the requirements of justice make choice and decision essential but not infallible. In an increasingly complex but professedly democratic society, things are not going to get any easier. And so we come to the question of the state and private life and whether the state should intervene to protect. The Englishman's home is his castle, and his personal liberty is his inalienable right, which he may defend by force if necessary, and in the leading case it was a clothes prop and a milk bottle, against any unlawful invasion by the state or its agents, or indeed by anyone else contrary to his consent. It has been so acknowledged in our law since Magna Carta, reinforced by the European Conventions on Human Rights, which, as you know, is now part of our domestic law. So far, so good. But note the key word, unlawful. For in our increasingly complex society, there are ever more of those who are entitled lawfully to intervene in our private life. The police and security services, social welfare and mental health agencies, and all manner of enforcers of debts and penalties. They all require the official sanction from a statute, and many require a court order as well. And it raises an essential tension between personal liberty on the one hand and the proper activities of the state on the other. And it is clearly illustrated, I think, by a consideration of Article 8 of the European Convention on Human Rights, which is entitled Right to Respect for Private and Family Life. And Article 8.1 says this: everyone has the right to respect for his private and family life, his home and his correspondence. That is fairly clear. That is the bit of Article 8 that most people know. But it is not the whole of Article 8. For Article 8 is a qualified, not an unqualified right. And Article 8.2 goes on in these terms: there shall be no other interference by a public authority with the exercise of this right, except such as is in accordance with the law and is necessary in a democratic society in the interests of national security, public safety, or the economic well-being of the country, for the prevention of disorder or crime, for the protection of health or morals, or for the protection of the rights and freedoms of others. Those are very wide grounds indeed, allowing the curtailment of the basic right under Article 8.1. But they do have two built-in safeguards. First, it must be in accordance with the law, and secondly, it must be necessary in a democratic society for those listed purposes. The first is protection against arbitrary executive action and has really been part of our common law for centuries. The second, however, employs the concept of proportionality that we met in the first lecture. To be necessary, it must not only be lawful and for the set purposes in Article 8.2, but the invasion must be proportionate to what is to be protected or achieved. And we saw how that came down to striking a fair balance in the individual case, ultimately, of course, a judicial function. Inevitably, therefore, private liberty and state power exist in a permanent tension in our society. And my purpose today is to explore the role of the judge, in particular as both gatekeeper and regulator, in the holding of that tension, and I want to do so through the prism of both the family court and the court of protection. There are, of course, many other areas, notably the jurisdiction of the administrative court and the remedy of judicial review. But I've chosen this particular approach for three reasons. First, these are the areas which have seen a significant growth in judicial power over the time that I have been a judge. Secondly, they tend to generate considerable public feeling, though that in itself introduces a further tension. For every failure to intervene, as in Victoria Climbié or Peter Connolly on the one hand, there is an excessive intervention, as in the alleged sexual abuse cases in Cleveland or the ritual abuse matter in the Orkneys. All they actually have in common is the generation of public fury and a real feeling in professionals of damned if you do and damned if you don't. And the third reason is they happen to be the areas best known in my own judicial experience. Now, this tension between private liberty and the activities of the state is quite legitimate and probably inevitable in a complex democratic community. We all prize our personal freedom and we resent our lives being nannied by the state. On the other hand, we do want a humane and civilized state, able and willing to protect those not able to protect themselves, and moreover, we want a state willing and able to do just that, whether or not the person concerned in their family wanted it or asked for it. And here we see not only the tension, but the source of conflicts of opinion about it. We've noted the two essential safeguards of liberty, lawfulness and proportionality. Lawfulness in modern times will essentially derive from a statute, and that may have further safeguards built into it. Let us take the Children Act of 1989 and the Mental Capacity Act of 2005, which are both foundational statutes in terms of our welfare provision. It is the Children Act that empowers the state to intervene in private family life by the taking of care proceedings. Of course, there will be many procedural requirements, but there are two substantive requirements. The first is found in section 31(2), which says that a court may only make a care order if it is satisfied, A, that the child concerned is suffering or is likely to suffer significant harm, and B, that the harm or likelihood of harm is attributable to 1, the care given to the child or likely to be given to him if the order were not made, not being what it would be reasonable to expect a parent to give him, or the child being beyond parental control. I have to say that definition is not immediately obvious at first sight, and of course presents real difficulties to translators where the people's concerned language is not English. At all events, this provision has become known as the threshold criteria, in that they are a factual threshold that has to be established before the court has any jurisdiction to intervene in private family life. That means that unless the harm suffered or anticipated can properly be described as significant, and that is attributable to a want of reasonable parental care, the state has no power to intervene compulsorily. The emphasis in practice is usually on the nature of the harm involved. It is not every incidence of harm that warrants intervention. Will you forgive me if I take the liberty of quoting some words from a judgment of my own, partly because they're reported, partly because they've acquired widespread acceptance, and partly because they've now been expressly approved by the Supreme Court. And it's in these words: "It follows inexorably that society must be willing to tolerate very diverse standards of parenting, including the eccentric, the barely adequate, and the inconsistent. It follows, too, that children will inevitably have both very different experiences of parenting and very unequal consequences flowing from it. It means that some children will suffer disadvantage and harm, whilst others flourish in an atmosphere of loving security and emotional stability. These are the consequences of our fallible humanity, and it is not the provenance of the state to spare children all the consequences of defective parenting. In any case, it simply could not be done. Significant harm is fact-specific and must retain the breadth of meaning that human fallibility may require of it. It is clear that it must be something unusual, at least something more than the commonplace human failure or inadequacy." End of quotation. I hope that will make it clear that it is only in a small minority of families that the state will be able to establish its right to interfere. If it does not, then it has no compulsive powers, and it must rely on parental cooperation to enlist help and to take advantage of services. There is a further safeguard, and that is that the welfare of the child must be the court's paramount consideration. That is the subject of the next lecture. For today, I'm simply concerned about the right to intervene in private life. So to the Mental Capacity Act. That too has a two-stage approach. The second is the requirement to act in the best interests of the protected person, and again, we will come to that next time. Our concern now is the basis on which that duty depends, namely that the person lacks capacity to decide the specific matter in question. For it is only if they lack capacity that the court has any jurisdiction to exercise a best interests jurisdiction. Now is neither the time nor the place for a detailed exposition of mental capacity law, though I did explore the concept of capacity in a recent Foundation Hour lecture here. Suffice it to say that capacity is presumed until the contrary is established, and that to establish incapacity, there has to be shown a disturbance or impairment to the functioning of the mind, and also an ability to understand, retain, or weigh all the information necessary for an informed decision. It is subject to an important further principle, namely that a person is not to be treated as unable to make a decision simply because he makes an unwise decision. The question of capacity is fundamental, for as I've said, unless capacity is established, the state has no right or power to intervene, save in those cases where mental ill health brings a person within the Mental Health Acts. 10 o'clock on a Sunday night. I happen to be the judge on call, for the Family Division has a judge on call 365 days a year and 24 hours a day. I was rung by a consultant in emergency medicine who had an elderly gentleman who'd attempted suicide but had failed, having taken not quite enough tablets. He needed to be washed out. If he was, he would recover, but if not, he would die. The patient was refusing all treatment. What was to be done? The only question was capacity. Happily, a member of the family was willing to speak to me, the psychiatrist having expressed the opinion that if he had to say the person had capacity, he wouldn't, and if he had to say the person hadn't got capacity, he wouldn't say that either. Fortunately, as I say, a member of the family was willing to speak to me, and it was clear from that conversation that this patient knew precisely what he was doing. He had expressed the view ever since his wife had died a few months before that he wanted to die and go and join her, and much though the family disapproved, he had been consistent about that. And accordingly, there was simply no basis on which I could find that the presumption of capacity had been displaced. Therefore, there was a direction for no treatment, and he duly died a few hours later. Personal freedom can sometimes come at a very high price and can severely test the human instinct to intervene and protect. But that instinct is one that has to be controlled. The judge is not just the regulator of protection, but the gatekeeper as to whether that jurisdiction can be exercised at all. However, there will be many cases, many more I think than is generally believed, when the state will have power to intervene. Nowhere is that more true than amongst our ageing population. And we now need to explore the sort of interventions that a judge may be required to authorise or indeed to order. And again, I want to start, if I may, with the Mental Capacity Act. Once capacity has been resolved and a finding of incapacity made, the court has the widest powers to act in the best interests of the protected person. That may include both their property and their personal welfare, and it may involve either a judicial decision or a judicial appointment of a deputy to take those decisions. The most controversial decisions tend to lie in the field of where someone should live, with whom they should associate, or what medical treatment they should receive. It is important to remember that at all times the court's powers depend on incapacity, and incapacity is decision specific. So, I had a case of a very wealthy older man, this is in the law report, so I'm breaking no confidentialities, who was in the early stages of dementia. There were many disputes which arose in his family out of his sudden announcement that he wished to marry his carer. And the issue arose as to his capacity to make the various decisions that were in question between him and his adult children. In fact, I decided he had capacity to marry, he had capacity to decide where and with whom to live, he had capacity sometimes to make a will or make a power or undo a power of attorney, but he had no capacity to manage his own affairs or indeed to manage his own litigation. Now, the court could only intervene where incapacity to make a particular decision was demonstrated. So the question of who he married was no business of mine. The question of where he lived was no business of mine. The question about whether he could make a will, and if so, what in it, or powers of attorney, and if so, what in it, would depend whether at the moment that he made the will or the power of attorney, he had capacity to do so, because his capacity was up and down. But in relation to his affairs generally, I was satisfied that he did not have capacity to manage them, and so orders would be made in that regard. Back to the powers which the court has, though. The court has power to commit a person to a care home without their consent and against the wishes of their family, provided that it is in their best interest to do so. That, of course, involves a deprivation of liberty, and we now have an administrative process, a bit like the Mental Health Act compulsory admission process, to oversee and authorise it, subject to a review by the Court of Protection. It is, however, a draconian power, which may have lifelong consequences for those affected by it. The court also has power to regulate personal relationships. I had to deal with a case of a young woman, again in law reports, addicted to sex but lacking the capacity to consent to it, as a result of which she had been grievously abused by all manner of men. But in order to protect her, it was necessary not only to require her to live in sheltered accommodation, but only to leave it with 2-to-1 supervision. That is a huge incursion on privacy and liberty for someone who is not to blame for the circumstances in which they find themselves. Again, the court has powers to regulate medical treatment. So I had to decide in respect of a seriously learning disabled woman addicted to smoking whether she should lose a leg to extend her life, something she'd never be able to understand or accept, or merely to provide palliative care. Those duties are entrusted to the judge by society and by statute, but I wonder how many of us even know of, let alone approve or consent to their exercise. Let's have a look then at how these things can work themselves out in family law. We thought last time about how facts are determined, and we will look next time at the concept of welfare. At present, I am simply concerned with the actual powers committed to the judge rather than how or why they are exercised. Of course, the court has very wide powers to determine inter-family disputes, but those powers are effectively only exercised on the application of a family member to invoke the jurisdiction of the court. More controversial are the powers exercised when the state intervenes in care proceedings. I want to take one example from each set of proceedings, public and private, to demonstrate the powers that exist and sometimes have to be exercised. And I want to start in the field of private law with the removal of children by one parent to another country, not about abduction, but removal with permission of the court. No parent may remove the child from this country, other than from a short holiday, without the consent of either the other parent or permission of the court. If the removal is to be permanent, this will have serious consequences for the left behind parent. Traditionally, this arose because the resident parent in a second marriage had a job opportunity overseas. But much more commonly these days, it arises because a separated parent wishes to go home. Transnational parenting is a rapidly increasing phenomenon. I've had American and Pakistani parents, English and Russian parents, English and Iranian parents, Welsh and American parents, and pretty well any combination you could think of. They may all have lived here, but once their relationship ends, one or indeed both of them are very isolated here. What is to be done? The problem is most acute when the parent who wishes to leave is also acknowledged as the primary carer of the child. And it is particularly difficult where the country of destination does not operate under the Hague Convention, or where both parents plan to leave the country, for then the court has no opportunity to repair the consequences of its order, for it will have no jurisdiction once the child leaves the country. And not every country, or even most jurisdictions, understand child welfare in the way that we do. And so the court has to assess and rely on the honesty and goodwill of parents, and in a separation, both are often in short supply. I found that a judge needs to be pretty cool-headed in these cases. I ask myself what these parents would have thought would be right had they considered the consequences of separation before conceiving the child. I know that's entirely artificial, but it's the nearest I have ever discovered to fairness. To allow a child to go to Iran or Russia or China may be devastating to the left-behind parent, but to condemn a child either to the loss of the primary carer or to require that carer to remain an isolated figure in a foreign country has potentially serious consequences for the child. These decisions have to be made, and judges have to make them. Their ramifications can be, as I hope I have shown, enormous. Let me then, in the field of public law, turn to the question of adoption, which is both politically high profile and also deeply emotive. The President of the Family Division has said that since the abolition of capital punishment, there is no more draconian order than the removal of the child from parents for adoption by a stranger whose identity and whereabouts are and will always remain unknown to that parent. Yet, such an order is not an unusual consequence of care proceedings today, especially where the child is very young. Its attractions for a child are obvious, and outcomes based on young placement for adoption are very encouraging. Indeed, the most recent piece of research, which I saw for the first time last Wednesday, shows that where children under 4 have been placed for adoption, then 10 years on, 97% of those placements remain intact. Now that is quite a remarkable figure, and is some evidence, not total, but some evidence, that adoptions may be a very useful way of meeting the needs of children. On the other hand, it is difficult to envisage a more profound or devastating incursion into private family life. Now, it's important to make 2 points to set this debate in context. Of course, the world generally has known of adoption for hundreds of years. The Romans knew about it, and they weren't the first people to think of it. But generally speaking, in ancient times, adoption was there to provide a male heir to a family. Adoption first found its way into English law in 1926. So we've only had it for 75, 80 years or so. 90 years, for 90 years. Its original purpose, and so it remained for the first half of that period, was summed up in the saying, "A homeless child for a childless home." In other words, it was a way of sparing children children's homes and placing them with families who had no children of their own. And so it went on. But even this was somewhat controversial, not least because our adoption law provides that an adopted person is to be treated in law as if born the child of the adopters or adopter. In other words, legally, the natural family are utterly extinguished, and no record of them remains technically, although obviously some court files do, but no formal technical record remains for that child. But in more recent times, adoption has become an integral part of the social armoury of child protection. Hence we find the increase in compulsory adoptions and the feelings that they inevitably generate. Small wonder then that our courts, whilst acknowledging the place and benefits of adoption, are keen to explore all other options. Parental consent may be dispensed with where the welfare of the child so requires, but full value must be given to the word requires. It is some apparent uncertainty about both this test for adoption and the need to explore alternatives to it that has caused a significant drop in the number of children being made available for adoption. And there has been a very significant drop in the last 12 months following 2 or 3 judgments in the Court of Appeal. It is also important to remember that the English concept of adoption is very much a minority concept in the world at large. And not only in the world at large, but even within Europe itself. It is the compulsory extinction of the natural parents which runs contrary to the jurisprudence of most other nations. The United States, Canada, Australasia, and a few other countries share our view, but even amongst them, we hold to this view the most tenaciously. Judges tend to be well aware of this phenomenon, not least because increasingly we are dealing with children from other countries and cultures who are subject to our jurisdiction because, as a matter of fact, they are habitually resident here, whatever their immigration status might be. Adoption highlights the tension between privacy and protection more clearly than most other issues, not least because it is final, absolute, and in practice irrevocable. If the court gets it wrong either way, the implications are enormous. Children can benefit remarkably by adoption, but it comes at a very high price to the natural family. I do not believe that we have yet achieved a consensual view in our society on this, although the current policy of all main political parties is very much in support of adoption. It would not be right to leave this subject of intervention in private life without a mention of the court's powers in the field of medical treatment. The court has power on the application of a family member, medical authority or local authority to authorise treatment or the withholding or withdrawal of treatment, even if such action will lead to death. How those powers are exercised is a matter for consideration next time when we consider welfare and best interests. For the present, it is necessary just to note those powers, which may be exercised in practice only by a High Court judge, both under the Children Act or the Mental Capacity Act, and occasionally under the inherent jurisdiction, which is a medieval concept in which the courts draw on the role of the Crown as parent of the nation to exercise powers that the Crown used to exercise in medieval times. Once again, they are considerable powers whose exercise is ultimately dictated by welfare or best interests. And I wonder again, how many appreciate the powers that are committed to judges, especially the High Court judges, let alone whether they approve of or consent to their use. I want to end this lecture, if I may, with a brief consideration of an issue which again highlights this tension between privacy and protection and is a matter at least of hot academic debate at the present time, and that is the rights of young adults aged 16 or 17 in respect of their own medical treatment, the child's right to determine their own body, as it were. I do not propose to enter into the academic argument here, but merely to describe the powers that exist and are exercised. In our law, all persons under 18 lack capacity in law to make decisions of this sort, and the decisions are, in law, a matter for their parents. Now, of course, in practice, parents increasingly share that decision-making with their children, but it never alters the legal position that in law the decision is for the parents, the holders of parental responsibility. However, by statute, a young person of 16 has the right to consent to medical treatment. And this was enlarged by the House of Lords in the Gillick case to include all young people who, in respect of any particular decision, met the test of capacity. However, it has always been held, on protective grounds, that they do not have the same right to refuse treatment. The young man refusing blood products, the young woman refusing treatment in the delivery suite, the young person refusing food or a course of treatment for cancer are all at risk of a judge overruling that refusal on welfare grounds, not least because in such cases the refusal may come at a higher price than the young person actually appreciates. However, it is controversial and in some respects anomalous, although I believe that we do meet both the requirements of Article 8 of the Convention and Article 12 of the United Nations Convention on the Rights of the Child. But the age limit is anomalous. A child faces the full rigour of criminal responsibility at the age of 10. A young person may consent to sexual relations at the age of 16, and a young person may agree to serve on the front line in Afghanistan at the age of 17. So there is a degree of arbitrariness in all age limits, and the actual judgment about the age limit is, of course, a political judgment, one no doubt that we will confront in deciding the appropriate electoral age in the referendum that is to come, and so on. Perhaps all that does no more than illustrate that in human life you can never have complete rationality because we are driven by other complex forces in addition to reason. And that is happily that we are so. If we were exclusively reasonable beings, we would be extremely boring species to live with. And we are driven by considerably more than just reason. In the next lecture, we will explore some of the values and drivers which form our concepts of welfare and best interests, which in turn determine how these compulsive powers are to be exercised in the individual case. In the end, we have to find a working balance between privacy and protection. The judge is the key gatekeeper in deciding when the state can properly intervene in private life, and the regulator of how that intervention is to be exercised. And it is essential, if that is to be accepted within society, that the judge must have the informed consent of society in so acting. And it is that question that remains the fundamental concern in this whole course of lectures. Thank you very much indeed.